Today's discussions will examine the pros and cons and what tips and strategies they have utilized in their presentations in their negotiations. Excuse me. Let me introduce Steve Lazarus, as he is a principal in the law firm of Lazarus and Lewis, who for 30 years has specialized in acting as an advocate for public employee unions. Also, Brian Butcher, who is currently the president and chief executive officer of Clements Nelson Associates, where he advocates and advises management clients in human resource management, including but not limited to contract negotiations. I have personally been with them at the same table in contract mediations and negotiations. Let me tell you, these two guys are really good at their professions. They're rock stars in their own right, and they advocate strongly for their respective clients, which is a pleasure to see in action. I would also like to introduce my fellow mediators. Many of you know probably Ken Hickey and our newest member on our staff, Shelley Ward-Tackett, as well as our research and training staff, Leisha Sapp, who is working behind the scenes today, Justin Brown, the administrator, and Tammy Blau. I'd also like to introduce Mike Allen, SERB's general counsel, who came on last March, and Mary Laurent in the Mediation Bureau, as someone you may need to contact if you decide to go to fact-finding or conciliation to get a panel. Additionally, and most importantly, I'd like to thank SERB's board members who are promoting SERB's mission to have orderly and constructive labor relations by letting us bring this webinar to you guys. And hopefully you get some educational benefit out of it. And most importantly, I think that no matter what you bring away from this presentation, it should be some strategies you might want to utilize in your upcoming negotiations. As mediators, I want to say that we like to set ground rules sometimes when we do mediations, but here in the mediation department, we want to have ground rules going into this webinar. I'll be asking most of the questions to the panel, allowing them to answer the questions in about a 5-minute time frame. If they're running a little long, I'll say, hey, you got 30 seconds or something like that, just to speed it along. And number two, while we have some set questions to ask the panelists, we'd also like the audience to participate. And you can do this by typing into the chat section, so Leisha or I can bring your questions to their attention. Do I have any questions from anybody out there at this point?
There's nothing in the chat yet, so you're good to go.
I appreciate everybody logging on, and let's get started. This question will go to Steve Lazarus. You raise your hand, Steve, so everybody knows where you are on this. There you go. When going into negotiations, preparation is key. What are some of the pros and cons you have found in preparing in the virtual realm versus in-person negotiations?
Yeah, thanks, Chris. Wanted to also echo your appreciation for the board and you all mediators and staff there for the great work you do and continue to do through this pandemic, and you're always available, so appreciate everything you guys do. So yeah, things have changed as a result of COVID and how we do negotiations. When you do something the same way for 30 years and hundreds, if not thousands of times, as I've done, I think you really notice some of the changes and new processes that are going to occur here. And some things have been better, and some things have been worse. I think on the good side, first of all, there's less travel time. We represent primarily safety forces, and we're all over the state of Ohio. And so the time that I used to spend in the car traveling to Columbus or Cleveland or wherever, I'm now in my office oftentimes doing Zoom calls like this. So that's been a real plus in cutting down on the time of things. I think scheduling meetings has also become easier, somewhat for the same reason that there's less time needed for people to schedule those meetings on a Zoom call, and also because they can schedule those meetings if they're somewhere else. If they're, I've sometimes meetings, people are parked in their car. They're not driving, but they'll be parked in the car somewhere. And so, that's very helpful to get things done. On the other side of it, though, some of the same issues create problems. And I think that many times people are perhaps multitasking when they are in the midst of a meeting. So, they may be, their phone may be muted and their camera actually may be turned off, and they may not even be there. You kind of ask a question to somebody and you get silence for a while. So you can't really tell if people are even present, much less engaged, when you have some of these meetings and they tune out, and you can't really see that they're not paying any attention to what you're doing. So that's a bit of a problem. You can schedule things easier, but not sure that people are as involved when you have those meetings. And I think another issue that has been challenging for me, when you meet with your group preparing for negotiations, sometimes you can look around the room and you can identify someone who is not very happy about what's going on. They're not saying anything, but you can just tell they got their arms folded. They're kind of looking away, or they're giving somebody else a nasty look or something. And in those situations, when you're all sitting together, you can try and draw some of that out, I think, a little more easily. And when everybody's in different spots and you're looking at 6 different faces, and maybe 9, 10 different people, and everybody's got a small little blob, and you can't even see sometimes all the people. Some of that, it's hard to keep up with some of that. And I think I've missed out on some issues that I have come back to problems later on that I don't think I would have missed had we all been sitting together in a room at the same time. So, you lose some of that synergy, I guess, but the convenience factor is probably much better. And then, trying to actually draft documents, and I'll usually try to, share written documents with everyone to look at, because again, if you're all together in a room, pass out a piece of paper, putting it up on a screen, sometimes it's more difficult for people to follow things on a screen than if they're reading them and writing on them at the same time. So I think it works. It's like anything else. There's a new tool. People adapt.
About 30 seconds.
Okay, people adapt, and negotiations, I think, have been the preparation. I think in the end has worked just about as well as it did before. Thanks.
Thank you, Steve. Brian?
Yeah.
You need me to repeat the question?
No, I'm good.
Okay.
I wanted to say thanks to the board, you and your SERB team as well, for allowing me to share my thoughts today. A lot of what Steve said, I think, goes for the management side as well. From a pro standpoint, obviously the drive time, our firm, like Steve's, represents clients all over the state. That windshield time can certainly be a barrier to efficiency. But what I think has kind of shocked me, and I think is a big positive, is by doing things virtually, and I'm going to tell you right now, not everybody's doing it virtually out there, but a lot of them are. But by doing things virtually, I think it's forced the parties to actually prepare more. And I'm sure Steve's walked into negotiations, and sometimes it's a miscommunication, sometimes it's not, where you sit down from the other side and you go to exchange proposals, and the other side says, "Oh, sorry, I thought you were bringing proposals today." And that happens multiple meetings. and you're 2-3 meetings into the set of negotiations, and nothing's really been done. By negotiating virtually, I think it's forced the parties to exchange proposals electronically, potentially in advance. That's the way I like to do it. It's forced me to do a deeper dive, like Steve said, with my team as to what their priorities are. I mean, we all, seasoned negotiators, all have their steps that they go through to prepare for negotiations, but I think the wrinkle of the virtual environment has actually forced us to kind of hone our craft in a different way. On the negative side, the body language, it's a problem. Negotiations, I wouldn't call it a science. I would say a lot of it is reading people. Steve and I are both lawyers, but I don't necessarily think you have to be a lawyer to be a good negotiator. It comes down to reading people, and I do think you lose some of that via the virtual environment. Now, if you have ground rules that you're going to keep your video camera up, I think it forces you on the front side to kind of do some of the things that can make negotiations as close as to what it used to be previously. I mean, the bottom line at the end of the day, we all want people to be safe. I think people are negotiating differently all over the state, and I haven't seen it as a negative going into the virtual world. And honestly, I think you're going to probably see more and more of this, even after hopefully we return to normal sometime in the near future.
Thank you. I think one of the things, if I can take away something as far as mediations go, it seems that the parties tend to, at least on a virtual realm, get to limit the issues down. That's one thing you can do, at least limit it down and talk to either party that way. So, and I appreciate your response. Brian, let me ask you this question. When preparing for negotiations, fact
Chris,
findings,
can we
or
chime in with a question real quick?
pardon me?
Can we chime in with a question on that real quick?
Sure.
So Chad asked, do you feel is it reasonable to request that each side share paperwork or proposals a minimum of possibly 12 hours in advance so that they can be reviewed and seen on screen?
I'll take this one. I think that's certainly reasonable. Now, the one thing that I think benefits the parties is to have that contact, whether it's the two chief negotiators in advance, and like Chris said, narrow down the topics. I think the one thing that can happen in the virtual environment is you end up doing double duty. We end up, making proposals on the same issues where there may be a more efficient way to do that. I have no problem exchanging proposals in advance. My style to negotiate is not to negotiate by ambush. I don't like to catch somebody off guard. I'm not trying to surprise somebody. I don't think that does well for labor relations. So advance exchange is perfectly fine by me.
Steve, do you have any follow-up?
Yeah, and Brian does a very good job, representing management in these situations where we'll talk sometimes ahead, and I think it's a great idea to get those proposals out. There are some times, though, that I think a proposal needs an explanation when it's given because it could offend someone without an explanation. And oftentimes I might make 3 different proposals on an issue, giving 3 different concepts on how to address that. Without an explanation, management may think I want, a wage increase, I want another step, and I want, another bump somewhere else, all in the same benefit. And that's not the intent. So sometimes you need to be careful when you do that. I think I've also seen times where some management reps want the union to go first, if you will, and to, you give us proposals since you requested negotiations, and we'll respond. And when possible, I discourage that because you really waste your first day of negotiations when you do that, because we'll come in with proposals. Management will then say, okay, well, thanks for these. We'll see you later. As opposed to if both parties bring proposals to that first meeting, you can actually have a substantive discussion and get things signed off and moving forward.
Okay, thank you. I have another question I'd like to ask. I'll start off with Brian on this question, Brian.
And
when
Chris, I'm
preparing
sorry,
for-
we got one more question that just popped up.
Okay, Lisa, thank you. No problem.
Jonathan asks, setting a limit on the issues that can be negotiated gives an advantage to management. Can you please explain why limiting might be a good idea?
Would you like Brian to take that?
I mean, from my perspective, if we limit it, I don't know that it's an advantage to management, but I think you got to understand the environment, understand what the goals of the parties are, and I don't think it behooves anybody to take a mature contract and bring 35 issues to the table. I just don't know that that's productive, and I think the parties will probably respond accordingly. It's the dynamics of each different set of negotiations that I kind of think drives that question.
Yeah, and I think the question is a little loaded when you say setting the number. I'll use the word issues that you said. It's issues without, again, depending on the advocate, right? But some advocates have taken that in a very liberal way to say, well, an issue is a proposal, and each article is a different proposal, and I've got 9 different changes that I'm proposing in this particular article, so that's one issue. And so I've been in a couple negotiations where there's been an agreement to say we'll each bring 10 issues, and you start counting how many actual substantive changes are in the proposals, and there might be upwards of 30. So, and that led to significant arguments, probably 2 days of arguments over whether we had the right number of proposals. And if we had just come in and just said, we're just going to start negotiation, we probably would have been more efficient. And I'll echo Brian's comments about, bringing in dozens of proposals is probably a result of not being able to manage your clients very well before you start negotiations. And that's part of what we'll be talking about later, of managing expectations. But I think it bogs down the negotiations if you got so much stuff on the table. But I'm generally not one to say, yeah, let's limit the number of issues. I kind of agree. Let's see where this thing goes. But I'm willing to listen to that if a management rep wants to move that way.
Chris, I think you're muted.
Leisha, is there another question?
Nobody more from the audience right now. You can go forward.
Okay, I saw Lori Rotterman had a question.
Yes, I don't know where to find the chat function.
Okay, it's up at the top.
Yeah, you should be able to make a toolbar, and then you see a little message that looks like a text box. If you click on that, it'll open the chat for you.
I do not see that as an option. I have a microphone and a camera, but not a chat box.
Okay, well, maybe you can talk to Lori. You can give your number to Alicia, and you guys can talk about that. I think we need to go on to the next question. This goes to Brian. When preparing for negotiations, fact-finding, and disciplinary issues, do you find that people want to delay holding the event until they can meet in person, and is that advisable?
So back in March, I think that was the initial reaction of many people on both sides of the table was, hey, let's put this in abeyance for 6 weeks. Let's see what happens. I think quickly we learned that this wasn't going to be a 6-week pandemic, and it was going to last a long time. Steve and I sat in a seminar probably around April, and the message was doom and gloom. This is going to kill labor relations, and I think those of us who have implored their clients to move forward on both sides of the table, because guess what, workplace issues don't stop. I think you've done your client a benefit. I think delaying things, it's one thing to delay things to understand how to use software appropriately, to understand exactly where you were going, but to delay things just because it's inconvenient or hard, I think is a huge mistake. Employees need you, employers need you, and just an example. Let's say you have a termination that occurred in February, and you've put it on the back burner for arbitration till December. I mean, not only is that employee going without a paycheck, but the potential of back pay to the employer is great too. So I've told my clients, obviously, I want them all to be comfortable, and me and my staff have been very flexible in how we continue to represent our clients. But I think delaying it is a huge mistake, and I don't think it serves anybody in our field well.
Thank you, Brian. Steve, you want to give a response?
Yeah, I'll echo what Brian said at the beginning of the pandemic. I think there was, gosh, maybe we should delay it. I think people have become comfortable with the various technologies. Arbitrators, mediators have all done a very good job of working with this process, creating chat rooms, et cetera, for people. So I do believe if I had a choice to do a virtual or a live hearing, I prefer a live hearing, just because you do lose a certain element of the just body language and tone and emotion and things of that nature that arbitrators are going to pick up on. So I can see a situation arising in the next, hopefully, 3 or 4 months when it appears that the vaccines are rolling out, that we are going to be able to move back to a live platform more effectively. I can see a situation in 3 or 4 months where there may be a desire to delay a hearing for a short period of time to get back to a live hearing. I could see that. I could see that happening. But for now, as Brian indicated, to wait 6 months, 7, 8 months, whatever, is just not tenable for people who need that labor piece to get an answer to their disputes. I would note also, Arbitrator David Stanton has put together a very extensive kind of a set of ground rules and safety precautions to actually have live hearings during this pandemic, temperature taking and social distancing, kinds of issues that I think is helpful. So there are some around here, but a lot of people are just not comfortable with that right now, understandably.
I'll make one comment. I've seen a number of fact findings and conciliations over the last year really tail off. I mean, it's gone from about 80 a year to about 40 a year. I mean, it's significantly down. So hopefully we can get back to more normalcy and can go forward. I wonder if people are holding off going to fact finding because of that. But any questions there, Alicia? Okay.
I don't see anything right now.
Okay, what types of technology and platforms have you found helpful in preparing for negotiations? And this is kind of a three-parter. Are any better than the others? And have you found a best way to exchange documents and update language in a remote environment? That seems to be a problem that I've seen. Steve, I'll let you answer it.
Yeah, so I found that a lot of employers have a particular kind of software that they have gotten used to using, and I'll kind of take the lead because I've used them all at this point, and I will basically say, yeah, if you want to do this kind of meeting, that kind of meeting, whatever it is, whatever you're most comfortable with, we'll make it work. I do think that the chat rooms, the breakout rooms rather, are critical. You've got to have that process, and I've had some people that are a little uncomfortable with the technology on, is somebody listening in on these breakout rooms? Is it being recorded, et cetera? So with those groups, we've kind of just jumped off and had a phone call, or we've all gotten on a call together, so that we can have a discussion. But most people have, I really don't have one platform that I say, well, we should really use this one, we should use that one, because I'm more interested in making sure that management is not thinking that there's something untoward going on here or whatever. We do have a Zoom account where we can get a huge group of people on there. I know some of the smaller ones you're pretty limited, but I haven't had a lot of technology issues. And the other thing, of course, I've got several millennials here at my disposal in my office who, I can say I haven't had problems because my problems get resolved pretty quickly, even if I don't know how to resolve them. So I may not be the best person to answer some of those frustrations that others might have.
What about exchanging documents, Steve? Have you found that difficult?
Yeah, I think as came up earlier, we will try to exchange stuff ahead of time. And then when obviously you want to try to get things signed right before you finish. And I'm sure you deal with this. I know you and Ken are always pushing that. Oh, I'm not leaving until you guys sign this thing. So that can be done, right? You can email it or share it, and then countersign different documents and send them to each other. But that's always good to get that finished before you get off that call. So.
Thank you. Brian, you like to respond to that?
I'm with Steve. I don't know that there's any platform that's better than the others. I do think that as you begin this process, that you got to give everybody a little grace. I mean, I think this webinar here is a perfect example of how minor tech issues happen every day. So I think you got to be willing to give everybody a little grace with respect to that. But I am actually amazed and actually very happy as to how people have adjusted to the different sorts of technology. I've been in mediations, arbitrations. The neutrals have had no issue navigating the software. We've done negotiations where we've signed via a screenshot. Everybody types in the chat box, I agree, and we take a screenshot. That might be a way to deal with the signature issue. I don't know that there's a right or wrong way. We've utilized, email, the countersign, and send things back and forth. I do concur wholeheartedly with Steve and you, Chris, as far as to making sure that people have signatures on stuff that they agree on prior to leaving, because a lot can happen between then and the next meeting. There is also a platform, Google Docs, lets you make live changes, lets each party to actually be in the document, and you can make live changes so people can see those changes on the fly. So the technology is pretty amazing. Breakout rooms are certainly crucial, or you at least have to be able to, let people hop off the line for a little bit to talk, because caucuses are an integral part of negotiations, as everybody knows, and privacy as well. But with respect to the technology, I couldn't say I like one better than the other. Honestly, I think they're all pretty similar.
Okay. Okay. Leisha, are there any questions out there?
We do have a question, and I also just want to remind people, if you're not a presenter, to turn off your camera. So we have a question from Dan, and it says, our city has outsourced negotiations to a local law firm. Do you see this much?
Who do you want to take this, Chris?
I'll let Steve take it.
Okay.
So yeah, I think it really depends on, I would say, the experience level of the HR director or labor relations person in a particular jurisdiction, and their comfort level with negotiations. So, you know, I don't think there's a right or wrong answer to this. I would say, though, that I have experienced on occasion a jurisdiction that has outsourced it, and they've had the rationale that you know, this negotiation is going to be unpleasant. We're going to come in there and do a lot of you know, things that are going to make the employees unhappy. And by outsourcing this to a law firm, we can wash our hands of any bad feelings at the end of this, because we didn't do it. It was those nasty attorneys. And I would just say, from the labor side, that doesn't work. That, you know, from the union's going to say, you know, if these are your attorneys, they take direction from you. And if they are doing things in a nasty way in negotiations, then those you know, those feelings are not going to go away when that local law firm is gone. So, you know, that really, I don't think, is a good rationale to bring someone in from our perspective, at least.
Brian, you have a say on that?
Not much. I mean, I think it's pretty common. I mean, that's the reason why both Steve and I have a job too, is we are able, this is what we specialize in. This is what our expertise is in. Like I said, I don't know that you have to be an attorney to be a good negotiator, but there are a lot of different intricacies and procedural issues to bargaining, particularly in the public sector, that you need to understand. And depending on one's level of expertise, I do sometimes think too, the more equipped the negotiator is from a skill set standpoint on both sides of the table, the smoother it goes, because of the expectations, because of the ability to manage a client, because of understanding, you know, the procedural stuff that comes up. I think it can be a benefit.
I would just add that, you know, managing expectations on both sides of the equation is really key to a successful negotiation. I would say that. Any other questions, Leisha?
We are good to go.
Okay. Next question, gentlemen. What has your experience been getting your team on board using the technology at issue? And I want to pose this to Brian, knowing that management usually has city government there on computers versus the union that may or may not be have the skill set to be on the computers and use the technology. Have you found that to be like people that run utilities or an ASME group that's out in the field driving trucks and stuff like that?
So I think negotiations is being done a little bit different all over the state, and it kind of depends on where you are in the state. You know, early in the pandemic, when there weren't as many cases, and you had certain rural counties that had, you know, cases that you could count on your hand, I think people, were taking safety precautions, bargaining socially distant, but it was in person. I think as the pandemic and coronavirus has spread, things have become more virtual, but I think you can do virtual in different manners. And I think that flexibility has enabled most of my clients to continue to move forward. You know, whether it's getting the union all together in one room and utilizing a conference room with socially distanced, of course, with masks on, but also using, you know, a camera so that they are meeting together, but not necessarily management's in that same room as well, to kind of limit the amount of people who are in a room. I think I do know that there is one group out there that does not want to meet virtually right now, and so you've had to adapt with that if you want to keep moving. And I understand the reasons why they want that, but I know the way I've instructed my staff is to be flexible. You know, I think obviously the number one priority is people's safety, but we got to keep moving. And I think unless you embrace a little bit of technology, you are going to be in that situation where, at least right now, where you're delaying stuff, in my viewpoint, unnecessarily.
Thank you, Steve.
Yeah, so a couple of things that I have had to deal with. One of them being bandwidth and people's ability on these calls to hear and get cut off. You know, so having some kind of booster or something like that available so that you're not going to get cut out is important. But I've also encouraged people who are, you know, on a laptop somewhere to use their cell phone for their you know, to listen and to talk, because that is going to be less problematic than trying to go through your computer. So that's been something that I think I've seen often, of people getting kicked out of the calls because their you know, their computers just they don't have enough power to stay on some of the times. Some of the other things I've had to explain, the you know, the mute feature. A lot of people taking these calls at home, they've got pets, they've got kids, and you know, they don't realize it, but you can hear all that stuff. So I think that's been an issue. And then, you know, sometimes the background, obviously, of you know, people's homes or so forth are usually fine, but occasionally you'll see some odd things as well. So, you know, I think that it's been pretty good. I think people surprisingly pick this stuff up quickly, and using this technology, you know, using it with their friends and kids in college and all that kind of thing. So I think, you know, people are really. I haven't had much trouble getting people, you know, comfortable with all this.
I personally have had issues where some of the people just want to be on the phone. They don't want to use the computer, especially when you go out to rural communities, because the bandwidth is just not as good. I've had that issue pop up here and there.
Actually, Chris, that's actually the major tech issue that I've encountered. It's not the ability to use the platform. It's the ability to have a good connection.
Right. Well, this question, I have any questions out there, Alicia?
Yeah, we actually have two from Jonathan. One specifically for Steve. He asked if he can address the issue of how union membership can bring pressure to bear on the bargaining process in the virtual context. And then we have another one for Brian after that.
Okay.
So as easy as it is to schedule meetings and so forth in the virtual world, if you have a management rep that is trying to delay negotiations, or, you know, for that matter, a union rep that's trying to delay negotiations, I think it becomes a little more challenging to really push negotiations forward in the virtual world, because there's all kinds of other reasons that can be brought up as to why we can't meet this week, or someone's out on leave and so forth. So I do think that there There can be more frustrations if there is a desire to delay negotiations, and some of that is frankly difficult to deal with. One of the things that I found helpful where I have management that is trying to delay things is to schedule several meetings ahead of time. In other words, we schedule our first meeting. That's usually the hardest one to schedule because you don't have everybody in the room or on the call with their calendars. So once you get that first meeting scheduled, at that meeting, I encourage to schedule 2, 3, 4 more meetings. So you've got them on the calendar, and maybe you won't need that many meetings. Maybe you'll resolve it the next meeting. But that's probably the best way to keep things moving forward. I think we've also discussed sending proposals ahead of time via email or because that will make things more efficient at the negotiating table because you'll be ready to go and maybe even meet with your team after you get those proposals and have counter proposals ready to go when you get there. So it's really some of the same issues that you would deal with in the pre-COVID world on moving negotiations along. Some people have a reputation for trying to slow walk stuff and other people don't. And that's probably going to be the case regardless of the platform.
Thank you, Steve. Brian's question?
And Brian's question is also from Jonathan. He asked if Brian can address how the technology may be used to resist union member activism that is weighing in on the bargaining process.
Hopefully I answer this question as Jonathan wanted it answered, but I think your obligations under 4117 are the same regardless of whether there's technology or whether it's in person. I guess if you're in a concessionary bargaining situation, delay is always a strategy, and Steve kind of touched on how you could advance negotiations forward, no matter whose side you're on. But I have not noticed any sort of, I guess, nuanced, technique or strategy from the union side to put pressure on management. For the most part, obviously it's different, but I think the same issues are there that were as far as in-person negotiation sessions. I don't know, Steve, have you noticed anything different?
Well, there's always been this tug of in negotiations, how much information do you share with your membership? And a lot of different thoughts on that issue. So the question that is posed is union member activism, and I would read that as opposed to union negotiating team activism, because you do have members, individuals out there that may get on social media now in a way that perhaps they didn't before, and press concerns, issues, and bring them to to a much higher level than perhaps before there was so much social media. But I haven't seen any change during the pandemic on that issue. I don't think that has changed this issue.
I agree.
Thank you, gentlemen. Any other questions, Leisha?
Nope, not at this time.
Okay. Next question, I'll have this one go to Steve. When preparing for negotiations, what information do you gather and what sources or resources do you utilize?
So, this is probably the most important piece of negotiations is the preparation and getting ready before you start, because a lot of times, a union will come there and say, we want more of this, more of that, more of the other thing. And management rightfully asks why. And, for some unions, the answer is, well, because we want more. And, maybe 20 years ago, that was a good enough answer that we just want more, and okay, well, we'll give you more. But that doesn't work. And so there really needs to be significant amount of research ahead of time on the union side to prepare and to advance your arguments on what you're going to go in there with. The first place in CERB is a wonderful resource for people who are doing negotiations. So CERB has reports on health insurance. They put out a report every year that is incredibly comprehensive, has great data on costs, on benefits, and trends. And so I would encourage anyone in this field to obtain a copy of the CERB annual insurance report. CERB also has reports on wage increases, percentages going back several years, and you can look at that information. They keep one that's even a quarterly report on fact-finding, conciliation. How much is being awarded in year 1, year 2, year 3. So great data. CERB also does what's called benchmark reports, where you can ask them for information on wages and all kinds of other benefits for particular types of employees for particular areas of the state. And you can limit it by population, all kinds of, and the people that work at CERB are the most patient people I've ever worked with because they will, take your questions and not, say to a person like me, you idiot, why would you ask for that? So they are extremely knowledgeable and helpful. So that's the first, I think, place to go is check with CERB on that data. You also are going to want to pay particular attention to bargaining history on the benefits that you're looking to change, and why does language exist the way it does, and having that history is very important. There's numerous clients that I've negotiated contracts for 20 plus years and understand the language, why it's there, and what was there before, and importantly, what was given up in exchange to get that language, right? Because all of a sudden someone says, well, we don't like this. It's like, well, did you know that, we gave that up to get this other thing? And so I guess, if you want us to change that, are you willing to give us back this other thing? If the answer to that is, well, no, we don't want to give that back. I mean, that's gone, right? So bargaining history, having knowledgeable advocates is very helpful when you're looking at those issues. Then we get to comparables, and comparables are always in dispute. What are the comparables? You've got, whatever it is the industry you're negotiating for. You're going to want to look at other people doing like kinds of work, and 4117 specifically addresses that as one of the criteria. So CERB can assist you in getting that data. And how do you determine those comparables? A lot of different factors you can look at: geographical proximity, population, median household income, median home value, are all things to consider. And oftentimes they're unique factors, types of jurisdiction, townships, counties, cities. So all of those things can come into play when you're looking at those external comparables. Internal comparables, am I right?
30 seconds.
All right. Internal comparables, another, what's being done with the other groups in that particular jurisdiction. I think there's distinguishing factors if you're strike or non-strike units. Other things to look at are public records. We send out numerous extensive public records requests, newspaper accounts of things going on in the jurisdiction. If you've had any grievances under labor practices that you need to address, MOUs, you always want to gather up all your MOUs from the contract period to incorporate those into your agreement. Finally, again, this is a long discussion we could have, but just giving you the highlight here. If there's been any abuses on the part of either party with very vague contract language, that negotiations is the time to address that. So.
Thank you, Steve. Brian.
Yeah, sure. I think Steve hit all the high points. From management standpoint, I think there's a few other things that you might want to take a look at. I like to go back 2 or 3 contracts and at least see why language has changed. Maybe the most important part of your presentation, because nearly every article in a collective bargaining agreement does have some economic impact, is to make sure that your fiscal officer has a good feel for what the financials are, what your ability to pay is, what your inability to pay is. Understanding that at the table that you may have to cost stuff out quickly to preserve momentum within a set of negotiations. I like to know what 1 cent cost and also what 1% costs, so that way we can do math on the fly quickly. With respect to the comps, the comparables that Steve touched on, CERB is obviously a great resource for that information. I just caution management when you are picking those comps, don't cherry pick. And by that what I mean, when you're doing a comp study for your management group and you pick all the rich employers, and then when you're negotiating against the union and you pick all the ones who are having budgetary issues, that does not bode well either for your presentation, for rapport at the bargaining table, or your credibility at hearing if you end up there. I like to look at median household income, see how that's escalated along with the tax base. Most public employers are financed by some sort of tax. So that can show how things have changed over 3-4 different contracts. I don't know that, once again, I don't know that it's rocket science. I think there's a lot of time and energy that goes into gathering this information, reviewing grievance logs from the previous year. It's what you do with that information after you have it, strategizing. And I think that probably leads into some of your next questions, Chris, is how you use that, how you position it for your proposals, and what you want to actually bring to the table.
Have you gentlemen, let me ask you, have you gentlemen utilized our research and training staff if you want to get comparables? I mean, the other day I had an issue with a firefighter unit and hours of work, and I wanted to look at all the hours of work throughout the state of Ohio, and Leisha, within like 15 minutes, provided me with that information so I could discuss with the parties at hand, what the norm was for here and there, as opposed to a 212-hour cycle. And it was very useful. Thank you, Alicia. But if I'm sitting there negotiating for the city or county or for the union, I'd be definitely putting our research and training staff on speed dial to talk to them going forward. That's one bit of advice I'd like to give to everyone out there. I think Steve's having some trouble getting the camera back on, but I think he's still there. You're correct, Steve? You still there?
Yeah, I'm here. I'm
okay.
Trying to, my camera's having a problem here. So.
Okay, no problem. Next question, I'll just ask Brian this. In preparing for negotiations, do you utilize a short-term or long-term approach or both in order to meet certain expectations of your respective teams? How do you look at that?
Obviously, a lot depends on the specific situation of your client. Are you in a concessionary bargaining situation? Are you in a position where you want to make systemic changes to your operations? But I think you have to use both the short term and the long term. I think one thing that some people forget is that bargaining is quid pro quo. It's not just one side comes in, makes their demands, and the other side just automatically agrees to them. One of the mistakes I think new negotiators have sometimes, and some of my clients, I have pretty firm arguments with them is that, they want the union to hold the line on wages, and they're adamant that they need to do that. And I'll say why. And unless you have a good rationale as to why that should be your position, that doesn't cut it at the bargaining table. You have to be able to articulate your reasons behind a position, and just because doesn't cut it. I'm sure the arbitrators on this forum today would say the same thing when they're sitting in fact finding and they see a position of one side or the other, and the question is, why do you want that change? And they say, well, just because, we need to make progress. But without some sort of, good rationale, particularly in mature contracts, you're not going to get that change. From the short and long-term approach, I think the one thing that is important to understand is, unless you are willing to blow up and possibly risk, labor relations at the table through the hearing process, that big changes don't often come. Usually they're small changes. That doesn't mean you can't get to where you need to be over 2 contracts, over 3 contracts, and that should be analyzed from a strategic standpoint. But to go in and make wholesale changes without the right financial conditions, without the willingness to either push a group to a strike or to take somebody to conciliation, that just doesn't happen. If Chris has $20 and I say, give it to me, he's not going to give it to me unless there's some sort of pressure one way or the other on him. So I think it's really important for those new to collective bargaining negotiations to understand that it can be a slow process and it can be a long-term approach to getting changes that you may need.
Steve, would you like to respond?
Yeah, I think I agree with Brian that, you really, I think there are times management comes into negotiations with unreasonable expectations of, wanting to take things. And similarly, I think that you have unions that will come in and have the same approach. And a lot of that really goes back to managing those expectations before you get to the negotiating table, and making sure that your team that they have reasonable expectations of what's going to occur, what can occur in that negotiations. That sort of information can be helpful, and also what I will often call with my negotiating team the rules of the game. What are the rules of the game when you're negotiating? And if you're a strike unit, there's a certain set of rules, and if you're a non-strike unit, there's a certain set of rules, and you need to understand those rules and where this may go if you can't work something out at the negotiating table. So setting those expectations ahead of time, I think, is very important. Looking at that long-term approach is I think the best way to look at negotiations as a fluid process. For new benefits, if you can obtain a new benefit in the contract, then that's something that you need to work incrementally on. There are times, however, that if the employer has the resources and you can demonstrate by all measures that you're losing people, your pay is behind, that an equity adjustment is in order, and that's maybe going to happen quicker than an employer might like it to, but having an experienced advocate there to give you some of that information as to what's realistic and what isn't realistic, I think is very helpful to the negotiating committee. But looking at that long-term approach, I think is the way you really want to go most of the time. But bringing your wage committee along with you, I think you've got to do that. There are times that you may actually take a proposal, where you've got a team that really is adamant about something and you've done your research and there's really not a good justification for a particular issue to go forward. But you may end up having to make a proposal on that issue just so that they can hear management say no. So, sometimes you have to explain that to the committee. Where are you going to go with this? Well, I've heard that if we ask for this, they're going to give it to us, whatever. And 10 out of 10 times, that's not what happens. But sometimes you have to make that ask in order to placate people. So.
Thank you. Any questions, Lisa?
Yeah, I actually have one that relates back to CERB's comparables that we can provide. So I'm actually going to ask Justin to chime in on this. This is
Okay,
from
Justin.
Jim. And he asked, is CERB going to have a COVID-19 impact tab? Post-COVID negotiations fiscally is creating fear.
Yes, so to answer that question, CERB has been compiling a list of filed contracts and wage negotiated extensions and MOUs. We've been looking at those and post-COVID. So since roughly March 1st, we've been capturing those into an Excel spreadsheet, trying to track what type of negotiations or what's been negotiated with regards to increases. And that is available upon request. The last time we ran it was right at the beginning of November. So we'll be creating another file here roughly next week. And so I'll make that available on the homepage of the CERB site so that you will all have access to that. And that'll be located under the news article for this particular session. So you'll have access to that. And then if you are seeking the other, the November version, that is available upon request as well. Just for that request and any other clearinghouse related requests, please feel free to fill out the clearinghouse research request form, which is available in the footer of the CERB website. So that form is available on every web page of the site. So feel free to fill that out and we'll get that info off to you.
That was a great question, and thanks, Justin. That's fantastic that you can do that. Let me ask Steve here a question. How do you narrow down the issues that you want to bring to the table? I know sometimes I've been called out where, there's 30 issues on 30 open articles, and I know if you're going to head into fact finding, that the fact finder is going to probably current contract language on most of those. Picking the 5 to 10 issues out of 30 that he or she would take up. How do you get your parties to narrow stuff down?
Yeah, that really is a challenge. I think the more experienced your negotiating committee is, I think the more likely they are going to understand what's realistic and what isn't. I've had situations where got a whole new committee. Nobody's ever done this before, and we'll have a meeting to discuss proposals. And I get there to that meeting, and they've got 40 different things that they want to take to the table. And as I indicated before, sometimes you just have to at least make the proposal. I've been in some ratification meetings after the union comes back with a tentative agreement, and the a member says, well, you didn't get us any more vacation time. We'll say, well, we didn't even ask for more vacation time because first of all, we sent out a survey to everybody and nobody put down they wanted more vacation time. But even if that was a survey issue and the bargaining team did the research and found out that the current benefit was right where it should be, and that member then at the meeting will say something like, well, you didn't even ask for it, so how do you know they wouldn't have given it to us, right? So there is a need sometimes to go in there with more proposals. I think that it's important, if you're going to do that, if you can't get your management or labor team to reduce those numbers, I think you need to try to signal to the other side at the table somehow that these are our initial proposals. In some way, making it clear that there's more on the table than you're realistically going to get, because otherwise it can lead to some retaliation, and I don't mean retaliation in the against the union, but retaliation in the sense of management then comes in with 40 proposals to reduce every benefit you've got, and you spend 4 or 5 meetings getting all this stuff off the table that probably shouldn't have ever been there in the first place. So it is. I think that is a very significant challenge that I don't have a perfect answer for, because it depends on the team that you've got. But as an experienced negotiator, I can assist that process by bringing with me significant research on the issues, on the internal, external comps, and where they all sit. And from my experience, most people are willing to listen to that after you explain, what a fact finder or what a conciliator in the safety forces would be doing, what kind of analysis that they would make. And based on, doing hundreds of these for the years, usually people will give me a bit of a slack on what we should be bringing into the table that perhaps they're not with someone who doesn't have significant experience at this. So
Let me ask you, Steve, just as a follow-up to your response, do you ever, when you go into negotiations, do you have a set of ground rules that you typically, have that you want to have the other side sign off on, or you don't do that?
ground rules, those are something that if management wants ground rules, I usually encourage that to occur before we actually have negotiating meetings. In other words, send those to me. We'll look them over. We'll get them back to you, because I have had negotiations where we've had disputes over ground rules for 2 or 3 meetings or longer, over the number of people, over how long meetings are going to be. My interest in those ground rules are 2 things really. I want to see if we're going to move in that direction. One is some kind of retroactivity waiver to make clear that if we can't work things out and we go to binding arbitration, that that person will have the ability to award back to the beginning of the labor agreement. And then secondly, I want to have some understanding about how people are going to be compensated on the union side for attending negotiations. Is it a time for time? Are they going to be there paid even if they're off duty, or so forth? So those are really the 2 issues that, if we're going to do ground rules. But I, as the years have gone on, I've become less enamored with ground rules, because they just seem to take up a lot of time and by law are not necessary.
That's a fair answer. And Brian, how do you narrow the issues down?
Sure. Just 2 seconds on the ground rules first.
Sure.
I think ground rules can be beneficial to outlining kind of the rules of the game and how the parties are going to move forward. If ground rules become a stumbling block, I think 4117 protects both parties just the same. So like Steve, if it's going to take 2 or 3 sets of negotiations to try to hammer out ground rules, I think that's probably you got bigger fish to fry. With respect to the retroactivity waiver, which is typically included on a union's request in the ground rules, as long as negotiations are moving forward, I typically don't have an issue signing it. As long as you got meetings, that the parties are not coming to the game too late after one side's continued request to meet. In my experience, if you appear unreasonable on retroactivity, that doesn't mean that your proposal has to be retroactivity, but to just refuse to sign a G11 because it grants retroactivity, in my experience, typically that's looked upon as unreasonable by a neutral, and the employer gets hammered for that sort of thing. The other thing with respect to narrowing down the issues that you asked, I want to make it clear that what we are telling you is not to ignore issues that are there, but just to bring issues for the heck of it. Unless you're setting yourself up and you know you're going to end up in hearing and the game's played a certain way, and you know you have issues out there to lose, I just don't think it does well for union and management relations at the table. I really and I try to dissuade my clients from just bringing issues just for the heck of it. You know, occasionally there's an intangible reason for an issue to be there that the employer knows that they're not going to get, but they're putting it on the table to send a message, you know, and I understand that, but I think that is the exception rather than the norm. And if you do, there are times when you are not going to get a deal at the table, and I will tell you that getting a deal at the table with the parties is the best you can get. But fact finding and conciliation are not the end of the world either. Now, are they fun? No, but they do provide finality to the process. And you know, there are times where, and I'm sure Steve can attest to this, he knows that there's just not going to there's not a deal to be had between the parties. It doesn't matter how hard he and I work on it.
30 seconds, Brian.
There's just not going to be a deal. And you know, mediators can assist with that, but occasionally, you know, fact-finding and conciliation are necessary vehicles to end the dispute.
Thank you. Any questions, Leisha?
We do. From fellow mediator Ken Hickey, he has the question: in the virtual negotiations, do you set a time frame for the session by scheduling the meeting, or do you say it will be all day?
On my end, typically I try to get negotiations 3 to 4 hours, and even in the virtual environment, that's kind of what we're shooting for. You know, I've certainly negotiated day-long periods of time. I have found it that virtually it's actually harder to keep people focused than in person. I think there comes a time that as long as both parties come to the table prepared, that there's a time that you can be efficient during the set time period and still respect, you know, people's other schedules, because everybody's got a lot going on. I like to go 3 to 4 hours, but I think that varies by negotiator and varies by client.
Yeah, I agree. I will sometimes, it really depends on some of the management negotiators. Some people are better for a day. Others, I know we can set it for 2 hours and we're not going to be there more than 20 minutes. You know, that is because, you know, they really don't have authority. They're there and they're going to take this and leave. So nice thing about scheduling negotiations for a whole day is that if they get done in an hour and a half, then I have the whole day to myself to do things that I wouldn't otherwise have if I just scheduled for 2 hours. So there's a benefit, I guess, there.
Real quick too, I think scheduling is actually an overlooked part of the negotiations process. You don't want to schedule too many back-to-back meetings where the parties don't have time to let the proposal sit in to do research, but you also don't want the meetings 3-4 weeks apart while you know, you're spending the first half of the next session trying to remember what you guys talked about last time. I think that's an overlooked part. That sounds very simple, but it can certainly derail or delay a deal if you don't schedule correctly.
Brian, and a follow-up to that, you know, would you utilize maybe a week break to be able to put the language together to be able to swap it back with your adversary?
Yeah, I mean, I think a week's fine. I'm okay with scheduling 2 sessions during a week as long as there's 2 or 3 days in between. But it also depends on, you know, if Steve's got 10 other contracts going at the same time and I got 7, that may not be real conducive to the process as well, because each contract does deserve attention and you want to make sure that you come properly prepared. It's a disservice to your client if you show up at a meeting and you're not ready to get stuff done.
Steve, the same question.
Yeah, I think at least a week. I found that, you know, generally you get as far as you can on an issue and that your team or both teams are going to have to meet to further discuss the issue before you get back together. So that's challenging with full-time jobs on the people on my end to, create that time in a day or two. And the other part is, as Brian alluded to, is sometimes, you come into negotiation and you're thinking, this is my bottom line or whatever. And I always dissuade people from saying this is a bottom line. I said that, it's a fluid process and we're going to see where things go. But I think sometimes it takes people time, and there's no other way to do it other than some time to start to adjust to a new way of looking at a particular issue. And if you're meeting every other day or something, sometimes people just aren't ready for that.
Okay. Any other questions, Lisa?
Not right now.
Okay. I'm going to kind of switch tracks here just a little bit. We're going to go into relationship building. One of the basic tenets of collective bargaining is having a good relationship between labor and management. In the virtual environment, how are these relationships being built, and how do you suggest improving on this going forward? And have you had any specific strategies in the same or different when meeting in person? I'll ask Steve.
Yeah, so the virtual world definitely has, I think, hampered some relationship building in the sense that you just can't go out and get a beer with someone or have lunch or whatever. And obviously, and some of this may be generational, but for me, sitting in a room and looking someone in the eye carries with it a little more weight than having a Zoom call with them. So those relationships, I think, have been a bit more challenging. So I think it's important to look for opportunities to build those relationships instead of just waiting for them to come to you and seeing someone at a seminar that aren't being held anymore, or at some kind of meeting on something else and pulling them aside. You really need to now be looking for opportunities to build relationships and collaborate. One of the things that I have done for years, I love to read the newspaper. It's just, and I still actually every morning go out on my driveway and pick up the newspaper in a little orange bag and bring it into the house and read the newspaper. And so when there are articles of interest in that paper to people that I work with in the union, or for that matter in management, something that I think they may be interested in, I'll send it to them. I'll send it with a little note, and generate some discussion, and so things like that, where if you can build those bridges and further those relations with management. Those things come in handy when something goes south and you need to talk to that person, and you've got that relation where there's probably a little more trust. It also, I think, didn't really dawn on me quite as much until issue 2 in 2011, where people on the union side certainly were not paying as much attention as they should have to building those relationships with the community and with the citizens. And we were at a juncture then where there was a desire to take away collective bargaining rights from employees, and we found that the citizens really stepped forward to say, we care about our teachers, our firefighters, our police officers. But since that time, I've been much more proactive in making that pitch to the unions to try to build those relationships as well with, shop with a cop, or, safety classes that firefighters might put on, or so forth. And that community outreach, I think, is something that you can't underestimate the value of that as well.
Thank you. Brian?
With respect to relationships, I think we're all professionals, and I think it goes without saying that you need to respect somebody could disagree with you, and that's part of their job, and they're a professional. And I don't know that everybody on this call needs to be lectured to about the golden rule, et cetera. But the one thing that I think can help to repair relationships where they are broken or where they're not broken, ensure that they're not, is to do what you say. So little things like if I'm going to agree to exchange proposals electronically before the meeting, that I actually do that, and it's not just one side sending it over. It's little things like that that I think definitely help build a rapport. But at the end of the day, too, a lot of times it's up to the employer and the union to make this work. I get to go home. Steve gets to go home. It's really incumbent on the parties to understand that there is a partnership. Sometimes it's years and years of, I don't know, pettiness, anger, whatever you want to call it, that's the impediment. But at the end of the day, somebody's got to be the bigger person and understand that we got to get past this because we are in this together. It's okay to disagree. There's processes in place to fix that, but being civil at the table, I think goes without saying, and I think people need to do that, whether that be virtually, whether that be in person. I think treating one with respect, it doesn't matter what environment we're in.
Thank you, Brian. Leisha, any questions?
There is a question from Chad. It's about fact finding.
Okay.
He asks that they had gone before fact finding, and the fact finder wrote that he agreed we were long overdue for a raise, but we were behind the agreed comparables. But the fact finder didn't want to make the city pay. Have you seen a union be able to push forward from fact finders' reports like that and get a ruling in their favor?
Do you want to take that, Brian or Steve?
I think Steve.
Yeah, sure. So obviously, depending on are you a strike unit or not, if you are not, going on to signing arbitration is obviously where you want to go with that. Issue number one is ability to finance. So the statute says, can the employer finance it? And so if the employer is in financial distress, then perhaps you're not going to have any luck, even if you are significant below the average there. But I will also note, because the question came up earlier about COVID and the effects of COVID, and there are jurisdictions, particularly the ones that aren't quite as urban, that have actually done quite well in the COVID world as far as their finances. And then others have been even. I think some of them have made cuts going into the COVID era, and that those cuts were based on assumptions of the economies being closed down, and that's not the case anymore. So revenues may be significantly over where they were being projected to be back in March. So, I have found some employer reps using COVID more as an excuse than actual fact based on financials that we get through public records. So that's your first issue, is can they finance it? If so, and you have conciliation as an option, and that fact finder has basically agreed to you, but not given a good rationale as to why they didn't award a greater increase. I don't think you're going to make up 17% in the contract, and that's part of that long-term strategy. But you certainly need to be well over the average increase if you want to catch up at all, right? Because if the average out there is, we'll say 2.5% for your industry and for the next couple of years on your comparables, and you're getting 2.5%, then you're still going to be 17% behind. So you cannot catch up that kind of a gap in one contract, but certainly I would advise that committee to, if the jurisdiction had the finances, to certainly go to binding arbitration and say we should get some of it in our contract.
Thank you, Steve. Well, I'm being shown that we have like 5 minutes left in our session. I think we can go over that amount, right, Justin? Okay.
Correct.
I have a couple more questions. The next question I'll ask Brian, does a lack of trust between management and labor have an impact on your preparation strategy?
Yes,
And
in
have
that
you personally experienced this too, or what?
I have. And I think I think from a preparation standpoint, if the lack of trust is there that you're not going to get a deal, you as the employer probably position yourself in a place that's most advantageous towards going to hearing, particularly if you have a conciliation group. I'm not saying that I would ever advocate bargaining to fail, but sometimes, like I said earlier, that the parties are at a point that they're just not going to agree because they don't like each other. And unfortunately, that happens. Another technique I might use is to get a mediator in there as soon as possible. CERB's mediators are great, FMCS are as well. And I'm not saying that just because Chris is on this call, but the advantage of using the mediator is they know what's going on all around the state. They can assist you in managing your client and, putting your message out there. And it's confidential. So, certain things may need to be said that the other side can't hear, because if they hear it, you're definitely not going to get a deal. I think using a mediator can be severely undervalued. That's always my first step if we can't get a deal, is to try to get a mediator in there as soon as possible. Because sometimes it's as simple as the other party's afraid to disclose their bottom line for fear that it's going to be utilized against them in one of the hearing processes down the line. Well, mediation provides an outlet to utilize supposals and certain things. The mediator can, push information to the other side in a manner that it's not an official position, but maybe it gets you closer. Maybe it gets 15 issues down to 8, and maybe it gets you to a point where you do have a deal. Because like I said earlier, the best deal is one that the parties can get at the table.
Steve, you'd like to respond to that?
Yeah, I think this trust issue is vital in negotiations. That gets broken down sometimes when one or both party makes, crazy demands. Again, I'll go back with my comment about sometimes the initial proposals may have a lot of stuff in them that
Have one bag of jewelry.
somebody's got a child there with their mic on, just FYI. So
Yeah, I think
But the other thing that can really create a problem is when somebody just says something that's just false. That they'll say, "No, we've got these. Our revenue is down by whatever," and it's not true, and that taints the whole negotiation to me. That if they're going to lie about this, then what else are they lying about? I had an experience with a management negotiator who I worked with for numerous contracts, and always would be something that, we can't do this, and we'd be able to prove it. And we actually had numerous fact finders and conciliators who said, management has been less than forthcoming in their presentations. And, you build up a paper trail like that over years, and it can be pretty damaging. But this particular negotiator made a comment to me one time, and he said, "Steve, I know I've told you for years that we're broke and we can't afford to give you a decent wage increase, but this time I really mean it." And I just sat there and I thought there's so many things wrong with what he just said. It was just one more time of this. And this was said in front of our whole team, and everybody just looked and were like, "Okay, so now we're supposed to believe you when you've acknowledged that you have been less than forthcoming with this for years and years." And so, those things make it extremely difficult to get a deal done. The other thing that comes up occasionally is you get a tentative agreement and one side rejects that tentative agreement. And, that has a significant impact on this trust as well, and makes it difficult, makes my job difficult going forward. Because, if management perceives that this was done in, in bad faith or it has implications going forward. And I hate when that happens. Obviously, I don't get to vote. I'm not one of the people who votes on that deal. And sometimes there's a good reason why it's rejected, but people who don't understand this process sometimes will just vote no because, well, what do we have to lose? And you can lose a lot going forward in these deals. It could get worse. So that's another thing that I have rarely, but I have experienced it, and it's a problem as well.
I will make a comment to both of you and everyone in the audience here that you have to be really careful as a mediator. I've been on a session where it's virtual and we have everyone there. We have, both reps and 4 members from each team. Notice we have a total of 11 people on the thing. And if you hear a geez, or you see somebody eyes rolling, if that person's on, or a giggle, little things like that can just drive other team members crazy. I mean, it'll really kind of derail the negotiations if you're not careful. So just be careful and mind your P's and Q's when you're on the internet and on the virtual platform. That would be my take on that. Have you ever had that happen to you, Brian or Steve, out there?
Oh, I'm sure. I have one client who their body language says exactly how they feel, and we've actually had to have that individual leave a couple sessions, not because that they weren't valuable, but they were derailing the whole negotiations. And
Right.
and we'd just bring them in during caucuses. They actually were a good sport and understood it completely. So, people are who they are. Bargaining is as much of a people thing as substance thing. So obviously, treating people appropriately is definitely conducive to good labor relations.
Right. Steve, any comment? Have you had an experience like that at all?
Yeah, I am usually able to manage that on my side because at the first caucus, I'll call somebody out on that. I said, this is not helping our cause, and I sometimes will use the example of, you get pulled over by a police officer for speeding. And there's a lot of different ways that can go, and much of it can depend on how you behave, and if you snicker and you say, don't you have better things to do? And why are you bothering me? And, let's get this over with. And, I want to be on my way, you're probably most assuredly going to get one result, and you may get a different result if you act respectfully. And same thing is true in any kind of human interaction. So, I'll call that out and explain why it really isn't in our best interest to behave that way. I do see it more often, though, on management side, particularly, in the work that I am involved in police and fire, where, there is this rank structure. And I think there are police chiefs, fire chiefs, et cetera, who see the world as, do as I say, and the negotiating process can be extremely uncomfortable for some of them who are not as collaborative and who are offended by people questioning their view on issues. So, usually I've seen those people removed from the negotiation after a session or two because management realizes on their end that they're creating an impediment to getting things done.
I have a closing question for both of you, and I'll let Brian answer this off the bat. And just like in a short 20-second clip, what is your single best piece of advice that you would give to your client as you would go prepare for negotiations in this environment presently?
I think just to be flexible. I know that's not any trade secret, but 2020 was a tough year. Start of 2021 is not going to be any easier, it looks like. Meetings are going to get canceled. You're going to have to do things differently. Just be flexible and understand that hopefully one day it'll all get back to normal. But it's been rough on both the employer and the union. So I just think we got to give everybody a little grace here.
Thank you. Steve?
Yeah, I think my advice is to always be preparing for negotiations. From the minute that you finish a contract, you should be collecting data and keeping files for the next negotiation. And, you know, having experienced representation to kind of guide you through that process, because the results of negotiation are directly related to your preparation and how you handle it.
Thank you, Steve. I believe we have one question from the audience here, and we'll take this one question, and I'll let either Steve or Brian pick it up. Alicia, what is that question?
Yeah, we have one final question. It says the rules of collective bargaining are contested terrain. Some states are trying to limit the scope of collective bargaining or trying to impose right to work. Some unions are pushing back and more ways to defend the workers' interests. We've seen more teacher strikes and impasses this year than in recent. How have these trends influenced your work with your clients?
I don't know that. I would say that the influence of that is just understanding that nobody typically wins when there is a strike. Even if the employer, you know, implements its last best, if strikes take forever to come back from a labor relations standpoint. So just making sure, I think maybe the crucial thing to come out of this question is just making sure that your client, and in my case management, understands what can happen at the end of the day if you don't get a deal. And obviously it's a little bit different for safety forces, but you know, people don't come back from strikes. Honestly, like you said, there's not many strikes either, because it's hard to walk away from a paycheck, but that doesn't necessarily mean it's good for both parties. So I'll turn it over to Steve.
Thank you.
Yeah, so, you know, I lived through issue 2, Senate Bill 5, and was one of the people that did debates all over the state on the union side. And that was really an existential threat to collective bargaining, public sector rights in the state of Ohio. And what I'm seeing now in Ohio is nothing like that. I mean, we have this sort of push on right to work. We've had the Janus decision, which I think has had really minimal impact on my line of work with police and fire. I also do work in Kentucky and negotiate numerous police contracts in Kentucky as well. And very different system over there as far as there is no binding arbitration, no conciliation. And I will just say that, you know, being a student of the collective bargaining process, Ohio has a very, very good system that creates an interest on both sides at reaching a deal that is fair and reasonable. You know, it's tried and tested, and CERB has done a great job since 1984 of creating a large body of law to flush this out. And you know, I think we have a wonderful system of collective bargaining in Ohio right now, and I don't see any significant changes on the horizon right now.
Thank you, Steve. At this time, we'll close the session, and I want to personally thank Brian Butcher and Steve Lazarus. Everybody give them a clap out here. And I want to turn this over to Justin. He's over there if you're listening, sir. You're going to have this put on the website, correct?
Yes.
the bullet
so-
points that we went
so,
over today?
This session has been recorded, and we will be posting this onto the website. It'll be the same location as where this the link to this event was located. So I'm gonna get that posted here in the next couple of days. It just takes a little bit of time to put that together, as well as having a link to the wage increases post-COVID since March 1, 2020. That'll go live as well. Should be right around the same time. So check back on the CERB webpage for that info. And if you need anything before then, feel free to send us a research request via the website, and we will address all your questions. Thank you.
Thank you, Justin. And I want a special shout out to my bud helping me out today, Alicia Sapp. Please, if you ever need anything in research and training, she's great at her job. And again, thank you, Steve. Thank you, Brian. I look forward to seeing you guys out and about, hopefully sooner than later. I guess we're out.
Thank
See
you.
you guys. Thank you.
Thank you.